All right, are we ready to proceed?
Yes, sir.
Yes, sir.
Mr. Blumberg?
Yes, sir.
Okay, great. Kelly? So the court will call cause number 323-113125-20. This is styled in the matter of Angel Ramon Cuellar. We're here for adjudication on this matter. The court will take judicial notice of all the documents on file in the court's record, and included in the file specifically is a petition regarding the child engaged in delinquent conduct filed on February 11, 2020. On June 3rd, 2020, the grand jury approved this matter for determined sentencing punishment for the offense of aggravated robbery. The child was served with a summons on July 29th, 2020, and the child's parent was served with a summons on this matter, Jesus Cuellar, on August 31st of 2020. Also in the court's file is a 3914 manifest for discovery filed with this court, a stipulation of evidence, confession, and disposition agreement. Also filed with the court under seal is a victim's court report and a social history. The court has yet to review these documents and will not do so until the appropriate time.
But may I interrupt just 1 second?
Yes, sir.
On the dates, you had mentioned that the state's petition was filed on February 11th. I have February 14th.
Oh, yes, it's the timestamp from the clerk bled over to the letters.
Okay.
So all I saw was the 1-1, but yeah, on further review, it's February 14th.
Okay, thank you. Sorry to interrupt.
Oh, that's all right. Yes, February 14th, 1:26 p.m. Okay, so Angel, I have a couple things I want to go over with you. First of all, is I need you, and is that your father, Jesus?
It is.
Okay, if you can both raise your right hands for me. Do each of you solemnly swear the testimony you're about to give at this cause currently at trial, that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Okay, please, you can lower your hands. Angel, I have a couple of questions for you. First, can you tell me what your full legal name is?
Angel Ramon Cuellar.
A little louder.
Angel Ramon Cuellar,
Okay, and what is your date of birth?
January 22nd, 2004.
Angel and Dad, can you switch places? Because I have more questions for Angel than Dad, and maybe he needs to be closer to the microphone. All right, thank you. All right, are you an American citizen?
Yes.
So I do have to go over a couple of things with you. First of all, I have to let you know the nature and possible consequences of these proceedings. This is a determinate sentence offense for aggravated robbery with a deadly weapon. A result of these proceedings could end up with a commitment for you into the Texas Juvenile Justice Department for a period of up to 40 years. And if you were not to complete your sentence by your 19th birthday, I could make a decision to transfer your commitment to a sentence into the institutional division of the Texas Department of Criminal Justice for you to serve the remainder of your sentence. Also want to let you know that these matters, if you do get committed, could be used against you in adult criminal proceedings, even though this is a juvenile case. Also want to let you know that these proceedings, to a limited extent, can be used against you in adult criminal proceedings. Do you understand?
Yes, sir.
You do have certain rights guaranteed to you by the Constitution of Texas and the Constitution of the United States. The Fifth Amendment guarantees the right to be silent. You do not have to say anything at all. However, it is my understanding that you wish to accept responsibility for your role in the offense of aggravated robbery with a deadly weapon in exchange for me following this agreement that your attorney worked out with the district attorney's office. Do you give up your right to remain silent?
Yes, sir.
You also have a right guaranteed under the 4th and 14th Amendments to what's called due process. You have a right to have a trial. You have the right to have me listen to the facts, the district attorney to prove everything. They would have to call their own witnesses, provide exhibits, and convince me beyond a reasonable doubt that you in fact committed the offense of aggravated robbery with a deadly weapon? Are you telling me that you do not need them to prove it up and you don't want to fight this case?
Yes, sir.
And also for any reason, if you decide you don't like me or for any reason at all, you wish to have a jury make this decision, you are entitled to have a jury listen to the same facts I would hear, and they would decide whether or not you committed the offense of aggravated robbery. Do you need a jury to make this decision?
No, sir.
You also have a right to confrontation. That means any witness that would testify against you, you have the right to look them in the eye as they are testifying, and if they are lying, they would have to look you in the eye as they are lying about you. Do you need to face your accusers?
No, sir.
You also have a right to appeal. However, if this is an agreed disposition on this case, if I follow this agreement, then you will not have a right to appeal. This will be final. Do you understand?
Yes, sir.
I also finally need to let you know that I am not required to follow this agreement. Now, I expect to follow this agreement, but I need you to understand that I do not have to. And if I choose not to follow this agreement, I will allow you, through your attorney, to withdraw your plea of true. So you understand I don't have to follow this?
Yes, sir.
Okay. All right, Dad, so I swore you in previously. Could you tell me what your legal name is?
Jesus Ramon Cuellar.
Okay. And what is your relationship to Angel?
He's my son.
Thank you. Mr. Youngblood, is there any reason why your client will not understand the proceedings today?
No, sir.
Is he fit to proceed?
He seems so, Your Honor.
All right. Angel, you are here today because the state of Texas has filed a petition alleging you have engaged in delinquent conduct, which, if committed by an adult, would constitute an offense against the laws of Texas. Namely, they are saying on or about February 14th, on or about December 31st, 2019, in Tarrant County, Texas, you intentionally or knowingly, while in the course of committing theft of property and with intent to obtain or maintain control of said property, threatened or placed Sabrina Chambers in fear of imminent bodily injury or death, and that you used or exhibited a deadly weapon, namely a firearm. Do you understand what they are saying that you did? Angel,
Yes, sir.
you understand what they're saying that you did?
The judge just read you what the charge was. I don't know if you zoned out or not. He can repeat it if you didn't hear him.
The connection is going in.
Okay, not a problem at all. Let me repeat that. Angel, you are here today because the state of Texas has filed a petition alleging that you have engaged in delinquent conduct, which, if committed by an adult, would constitute an offense against the laws of Texas, namely aggravated robbery with a deadly weapon. They are saying on or about December 31st, 2019, in Tarrant County, Texas, that you intentionally or knowingly, while in the course of committing theft of property and with intent to obtain or maintain control of said property, threatened or placed Sabrina Chambers in fear of imminent bodily injury or death, and that you used or exhibited a deadly weapon, namely a firearm. Do you understand what they're saying that you did?
Yes, sir.
State waive opening?
State waives opening,
Any exhibits from the state as to adjudication?
not as to adjudication, Judge.
Respondent, any exhibits or witnesses towards adjudication?
No, same response.
All right, so Angel, what I have here is a stipulation of evidence. Do you recall seeing this document?
Yes, sir.
Okay, did you go over this document with your attorney?
Angel, can you hear?
Yes, sir.
Okay, did you go over this document with your attorney?
Yes, sir.
All right, so do you understand what the word stipulation means?
No.
Okay, I don't expect you to. Stipulation is a legal term that means it's a fancy word for agreement. Okay? So when in court, when two people stipulate to something, They're saying we agree, we're saying that we agree in front of a judge, and that forevermore, we will never go back and argue whether we're in agreement. Right? So for example, if I was to say your dad is wearing a black shirt, is that something you'd agree with?
Yes, sir.
And so you understand that if we stipulate to this, that 50 years from now, we cannot go back and argue about what color his shirt was on this date. You get it?
Yes, sir.
Okay. However, if I was to say that Mr. Youngblood was wearing, let's say, a face mask, okay, is that something you could agree with right now?
No.
All right. And we could not stipulate because there may be an argument 50 years from now about whether he was wearing a face mask at 1:49 p.m. on January 25th. And if we had stipulated, we couldn't argue about it. But if we don't stipulate, that leaves it open for discussion. Do you understand? Angel, do you understand?
Yes, sir.
Okay. So what I have here, this document that you went over with your attorney, is called a stipulation. Everything in this document, if you stipulate to it, that means it will go down forever as you agreeing to it. Do you understand what I'm saying?
I guess they're having technical difficulties, Judge.
Yes, sir.
So my
But
question,
let me interrupt. I apologize, Your Honor. Did you hear every word the judge said, or is this cutting in and out?
It's only my audio that's cutting in.
Well, it's important that you be able to hear what the judge or anybody else says. So I'm asking you, are you able to clearly hear everything he's saying or not? Or since you're not answering, can you hear everything I'm saying?
Is the communication back to you guys. We can hear everything and we can see the judge. But as we speak, it's not communicating back properly.
So your audio is not working, your volume for your voice.
Correct.
okay, so your audio, your speakers are working and your microphone is not?
Yes, sir.
Well, Mr. Youngblood, do you still wish to proceed?
Mr. Lewis, how far away are you from there?
Approximately 50 feet. Let me run over there and see if I can't troubleshoot.
Could we stop for a second, Your Honor?
Sure, we'll go ahead. We're in recess.
We're still on there.
Mr. Youngblood,
Sir,
can you hear
I can.
You might-
clearly, distinctly?
Yeah, 1, 2, 3, 4, 5, 6. You hear all that?
Yes, sir.
Can you repeat it back?
1, 2, 3, 4, 5, 6.
Okay, looks like it's fixed then. Thank you, Bob.
What I'm hearing, just for the record, is that they were able to hear everything coming to them, but apparently not able to communicate effectively on the,
Okay, I'm sure the judge will cover that more back on the record. Thank you.
okay.
Just take off your mask so they can speak a little bit louder.
Mr. Youngblood, what are your thoughts?
While we were on break, Mr. Lewis seems to have resolved the problems, and it was said, though but not recorded, I don't think, by the court reporter, that during all the previous times when the court or I or anyone had been talking, they
We're
were.
still not on the record.
Oh, okay.
I just don't know if you want to, my question is, do you want to proceed or you can do this in person?
No, I'm fine to proceed. I just wanted to have the record reflect that they have heard what you have said.
We can do that once Mr. Lewis returns to his office. We'll go back on the record.
Thank you, Judge.
I don't know how we found each other, but I'm glad we did. That's the best thing Tim did for me, left me you and I. Yeah, Santoro and Milbridge was not a deal. Wiseman and Peltier, yes. Marion King. Okay, so we're back on the record after a short recess to deal with whether we can proceed through Zoom or in person. Ms. Youngblood, any objections to continue through Zoom?
No, sir. It looks like the audio issues are resolved.
So, Angel, back to the stipulation that I'm holding up in front of your screen. My question for you is, everything in this document, is it true or not true?
True.
Is the enhancement that there was a deadly weapon used in the offense, is that true or not true?
True.
Are you saying true voluntarily?
Yes.
What does voluntary mean to you?
Of my own will.
Of your own will. And you were saying true of your own will?
Yes.
Did anybody threaten you to say true?
I'm sorry?
Did anybody threaten you to say true?
No, sir.
Did anybody coerce you, like force you to say true?
No, sir.
Did anybody induce you to say true, like offer you any kind of reward or money for you to say true?
No, sir.
Are you saying true because it is true and for no other reason?
Yes, sir.
All right, closing arguments from the state?
Sorry, Judge, we'll waive.
Closing arguments from the respondent?
No, sir, we have none.
So based on the competent evidence from this hearing, the court will make a finding of delinquency. Specifically, the court will find the allegations in the petition in paragraph 1 was established by the evidence, and the court will make an affirmative finding that a deadly weapon was used. That will conclude adjudication for this matter. Are we ready to proceed to disposition?
Yes.
Yes, sir.
All right. So the court will call cause number 323-113-125-20. This is styled in the matter of Angel Ramon Quillar. We are here with the court having previously adjudicated this child as delinquent for the offense of aggravated robbery, finding it true that a deadly weapon was used for the offense on the date of December 31st, 2019. Opening arguments from the state.
None from the state.
Okay, so we'll do allocution after exhibits. Any exhibits or witnesses from the state for disposition?
Yes, Your Honor.
Right. So which one?
Okay, we have, of course, you've already taken under seal the social history and the victim court report, but we would additionally call just briefly Miss Sabrina Chambers here on Zoom.
All right, Ms. Chambers, if you could please raise your right hand. You solemnly swear the testimony you're about to give at this cause currently at trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, thank you. You may lower your hand. Mr. Boneberg, please proceed.
Thank you. Ms. Chambers, could you just tell the court how you are involved in this offense?
I worked at 7-Eleven overnight. I guess I'd worked there for about 8 months almost. And on New Year's Eve, I was cleaning the front glass, and some young gentlemen at the time, I didn't know they were covered, their face was covered, came in with a gun at my head and took some money, I think some jewel pods and cigarettes. So
Let me ask you another question. You were working overnight that particular night for 7-Eleven,
Yes.
correct?
yes, sir.
And you were the clerk on
Yes, sir.
duty at the time.
Yes, sir.
As a result of this offense, you know that there was another individual charged, a man by the name of Adil Sayani, correct?
You cut out.
Sorry, you know there was
Yes, sir.
another individual charged, juvenile by the name of Adil Sayani.
Yes, sir.
Okay, and you were present at that disposition hearing last month, I believe, correct?
Yes, sir.
Okay, and then there was a third individual who, subsequent to this, committed suicide, but he was also involved in this offense too, correct? I'm sorry, I missed your answer.
Yes, sir.
Okay, thank you.
Um,
All right, and so there being 3 individuals involved in the offense, we have 2 here now being held responsible for that offense. I want to ask you about any loss that you've suffered as a result of this, meaning right now limited to monetary loss. Okay. First off, you had sent in a form which the judge has a copy of. It's called, in our verbiage, a victim court report, but it detailed on there in your writing, I believe, income loss from work of $600 and other expenses, another category of $1,000. Could you just tell the court briefly what that, how you can back up those losses, what they're from, please?
So the $600 was the 2 days that I took off after it happened. I went back to work for about 2 weeks, and just the anxiety of the door at night, I just couldn't do it. And so I told my employer that I was going to be looking for another job, and he just let me go. So I was off work for 3 weeks before I found another job, and then found another job, and it took 2 weeks to get paid. So I got behind on rent, and that's where the $1,000 comes in with late fees.
Okay. So the $600 is from the 2 days that you took off directly after this happened on December 31st, correct?
Yes, sir.
Okay. And then the $1,000 would be rent for which month?
For February.
Is that rent for an apartment or a house or something else?
It's for a house.
Okay. All right. Do you share that rent with anyone else?
No.
Okay. So you are responsible for that full amount.
Yes.
And did you in fact have to, how did you end up paying for that $1,000 you were out? What happened?
My mom, and then I repaid my mom.
Okay. All right. Now, there's been some discussion prior to getting on the record today that you were going to get documentation for that month's worth of rent. That'd be February of 2020. Is that correct?
Yes. Yes.
And have you made any headway since we recessed the hearing from this morning, or do you still need?
Yeah, I'll be picking up that documentation as soon as I get off work. I'm currently at work right now.
Yes, ma'am. Okay. And you'll be able to provide that to Ms. Navarro with victims assistance either later on today or tomorrow?
Yes. Yes. By 8 a.m. tomorrow.
Yes, ma'am. Sorry, Judge, if you'll just give me 2 seconds here. Okay, Ms. Chambers, the court will give you a chance to address the respondent in a few minutes here regarding your allocution. At this time, regarding the loss of time from work and rent and the restitution, Judge will pass witness.
Mr. Youngblood, Cross?
Thank you, Judge. Yes. Ms. Chambers, it was made clear to me by Mr. Bonebar on phone conversations that the 2 days that you missed work were because you were just too upset to work. Is that hasn't really been said on the record? Is that why you missed the work?
Yes.
That's all I have, Judge.
Okay, so Mr. Boneberg, redirect.
None, Judge.
So Ms. Chambers, I'm trying to understand. So you made approximately $300 a day?
Yeah, I worked 12-hour shifts at like $12.50 an hour, I believe.
Okay. So this is, okay, I think it's my math. Trying to figure out, so you lost $600 because you could not work for 2 days after this, after you were the victim of the robbery, right?
Yes, sir. Sorry.
Okay. And then what I'm trying to figure out is how much was your rent?
$725, and then I accrued late fees after 5 days. It didn't get paid till like February 15th, I think. I'll have to go back and look. I'm not, it's been almost a year.
So you had to pay $275 in late fees?
Approximately, yes.
So this is where I'm trying to calculate the math. So, but your rent was due January 1st, right?
My rent was paid for January. It was due February 1st when I quit working to find another job in January.
You were let go.
Yes. And I was off work for 3 weeks and then didn't get paid for 2 after I found a job. So 5 weeks of being able to get paid. I wasn't able to make the rent on the 1st of February.
Okay. All right, Mr. Brumberg, next witness.
Oh, Your Honor, may I interject? Because you made me think about it, I got my calculator out. So $12.50 times 12 hours is 150. And I think it was 2 days missed. And
Yeah.
so that should be 300. Is that, Mr. Bromberg, is that what you are asking for?
Well, she said she works 12-hour shifts.
Yeah, but 1250 times 12 hours is $150. So 2 days would be 300.
I was going to ask Ms. Chambers an additional question based off
Yes.
this question.
Please do.
Okay. Ms. Chambers,
Yes.
yes, the defense attorney is correct in doing the math. It looks like that 1250 times
Yes.
12 would be $150 times the 2 days would be $300. Where are you getting the $600?
I don't know. When I filled out that paperwork, it was probably, I don't know. I'm not good at math, obviously. So
Okay. So,
work at $12.50.
all right. So the $600 should say $300
Yes.
because you understand that there is a co-respondent that is paying restitution now based on these figures that you gave us. Okay.
Yes.
Okay, so we'll need to correct that. All right. So then, Judge, it does look like that should be corrected to 300, and we are asking for joint and several between the 2 living respondents, but that would take that down from $800 to, I believe, what would end up being $750, I guess. Let me see.
675 or 650?
Right, 650. Sorry, you're right. You're correct. 650.
Anything further from this witness, Mr. Youngblood?
No, thank you for letting me clarify that, Your Honor.
Mr. Blumberg, anything further from this witness?
No, thank you, Judge.
Call your next witness.
State has no further witnesses.
Respondent have any witnesses or exhibits?
No, sir.
All right. Allocution.
Yes. Ms. Chambers, at this time, you can go ahead and give your allocution, please.
Yes, I don't have anything written down. I'm just gonna say it from my head and from my mother's point, and somebody that's also been on the wrong side of the law at one point. I have since turned my life around, and I hope that you take away from this something good and know that what you're getting as consequences is really a slap on the hand for the crime that you committed. I do have 2 children that the scenario could have went all different kind of ways. Somebody lost their life. I could have lost mine. And I work with I do a lot of service work now. And I just hope that you take some good from what's happening right now. That's all I got.
Okay, thank you. All right, closing arguments.
Judge, we would ask that you follow the plea agreement as detailed in the stipulation document there. We would ask that you reform that restitution amount to $650. And as I understand it, we're waiting on some additional documentation anyway, but otherwise would ask that the court follow the plea agreement detailed there on the stipulation under the determinate sentence approval. Thank you, Your Honor.
Youngblood.
We also ask you to follow the plea bargain, which is why we signed it. And we understand the court will wait 30 days. And if the state hasn't responded on the matter of the rent, that will just simply not be part of the restitution. But we expect from what we hear that will be no problem for the state.
So then,
I assume they'll let me know so I can review that and object if I have an objection.
So at this point, the parties are asking me to order restitution at $150, and that part of the disposition can be modified within the next 30 days, just by agreement.
Yes, sir.
Is that correct, Mr. Blumberg?
Yes, sir.
Okay.
Going, it looks like to a maximum of $650. But right now, $150. Yes, sir.
So the court, having considered all the competent evidence provided at this trial, will find that there is a need of rehabilitation and that protection of the public as well as the child requires disposition to be made. The court will follow the disposition agreement. However, the court at this rendition will vary on 2 matters. One is the agreed amount of restitution of $800. The court is not following that, which doesn't bounce a plea. Simply, the restitution is ordered at $150 at this hearing. And so the other change is, Mr. Quiller, I am committing you to the Texas Juvenile Justice Department for a period of 5 years. Right? That means I've actually sentenced you, and that before your 19th birthday, I could decide to transfer you to the adult prison. However, I'm going to probate this sentence, which is this is following the agreement that your attorney and the district attorney made. However, I'm going to vary from the 2 years, and I'm going to put that at 3 years. right? And the reason why is because I want to have a hearing before your 19th birthday to determine whether I transfer you to the institutional division, or I'm sorry, transfer you to the adult courts for adult probation supervision. A large part of you not being transferred to the adult courts is going to be whether or not you follow these terms, including the restitution. This is really the only way I can assure Ms. Chambers that you will receive, or she will receive, all the restitution, is a specter of prison being over your head. This is also to ensure that you're taking the counseling programs and that you are making better decisions in your life, including the no contact order. But in essence, the agreement is for probation, and I am following giving you probation. I'm actually going to make an entry in here. That I am not opposed to discharging you at 2 years of probation if the restitution is paid in full. So I'll let you off probation early, as long as the restitution is paid in full. But Ms. Chambers deserves this at the very least. Right? I'm also going to assess community service at the amount of 80 hours. So you will have to do community service. For this case, you are to have no contact with the co-respondent. You're supposed to take the required counseling and assessments that's required. I do believe that you do have to. So remember, I think he requires a DNA sample on this one because of the level of offense. Right. Okay, so Mr. Quiller, you will be required to provide a DNA sample that goes into the state database, and that's because you were involved with a crime involving a deadly weapon. If you do not pay restitution or you have problems on probation, we will have a hearing before your 19th birthday for me to decide whether to transfer you to the adult courts for the remainder of your supervision. If you get your probation revoked before your 19th birthday and I commit you to the Texas Juvenile Justice Department, we will have a hearing before your 19th birthday for me to determine whether I transfer you to the adult prison system to complete the remainder of your sentence. If you end up going to TJJD, your case in its entirety can be used against you in adult criminal courts. Furthermore, the court will make a finding under Chapter 54 of the Texas Family Code that the child's parent or guardian made a reasonable good faith effort to prevent the child from engaging in delinquent conduct, and that despite the parent's efforts, the child continued to engage in such conduct. This court will waive any requirement for community service that may be imposed on a parent under this section of the code. Restitution is ordered at $150. Specifically, the reason for this disposition, Mr. Quiller, is that I am deeply concerned about children that are involved with guns, around guns at all. That gives me great concern. And you do need supervision to make sure the rehabilitation is concluded. In conclusion, Mr. Quiller, I'm letting you know that your case could potentially be transferred to adult criminal court for supervision, that I follow this agreement so you do not have a right to appeal. Depending on your case, you possibly have a right to seal your records. That is something to consult your attorney about. And Mr. Boneberg, there's nothing in the record to indicate the victim or intended victim was under 17 years old, so the court cannot make such a finding.
Yes, sir.
So Mr. Lewis, you can come by and make sure you get copies. I have the judgment entered into the docket. I do have the certification of right to appeal. Please provide a yellow copy to the child and the green copy to the father.
Yes, sir.
Is there anything that I missed, Mr. Youngblood?
No, sir. I do have one question of the court, and this is not due to delay on the part of the prosecution or the defense. It's mostly just COVID and the general nature of the beast with this type of case. He's been on what amounts to a probation for a year now. And so I wondered if the court could consider go ahead and just make his probationary period 2 years with the understanding that he does pay the restitution. And
So the idea is if Ms. Chambers is not made whole, then I will transfer him to adult criminal court.
I get what the court's saying.
Yeah, if he does make it whole, I've actually made a docket entry that I'm okay early discharge from probation at 2 years. Like so it's everything that he's done. But no, I want the specter of going to adult prison to weigh over his head to make sure that the restitution is paid. That's all I can do to guarantee, because once I just place him on supervision, juvenile probation isn't that diligent in making sure restitution is paid. That's the only way I can personally get involved in it. Okay.
Yes, sir.
All right. All right, that'll be the order. Mr. Bloomberg, have I missed anything?
No, but on that point, Judge, then to clarify, he must also follow all the other terms and conditions of probation, correct?
Oh, yes. So if he's picked up a new offense, if he's got other issues with probation, but if he's doing everything right at 2 years and restitution is paid, I'll cut him off early.
Yes, sir.
It's the only, I mean, I could have done 2 years and 6 months as far as that's concerned, but I wanted the specter of him being revoked or going to adult criminal court and it's not that much of a restitution amount. I mean, hopefully he pays this within the next 6 months. Right.
Yes, sir. Then nothing
Okay.
further from the state.
All right, Mr. Youngblood.
No, that's it, Judge.
All right. Thank you, everyone. That'll be the order of the court.
Yes, sir.
Thank you, Judge.
Good luck, Ms. Chambers.